The judge just ruling former Trump lawyer John Eastman should be disbarred. You'll remember Eastman is one of the key figures at the center of Trump's plot to overturn the 2020 election. In fact, he was known as the architect of the fake electors scheme.
Where more than a dozen witnesses detailed Eastman's scheme to undermine the 2020 election. And this also comes at a time when several of the attorneys who did back Trump or once backed Trump are all in professional peril.
Hey folks, welcome back. Hannah is here. So let us get started. Multiple lawyers who actually worked for Trump sat in the room, drafted the strategy, built the defense, have walked into court, raised their right hands, and confessed to crimes under oath on the record. And now those same lawyers are sitting across from prosecutors, walking them through the evidence and helping build the very cases they were once hired to destroy. Trump's own legal firewall has become the prosecution's greatest weapon. No social media rant can erase what is already on the public docket. Now let us be straightforward with each other from the start. The specific viral visual that has been burning up the algorithms, the one where a group of Trump's trial attorneys stand up in the middle of a heated hearing, confess to fabricating evidence or suborning perjury, and then get physically removed from the courtroom by a furious judge, that exact cinematic moment is a dramatization.
Do you still think the election was stolen?
Absolutely.
John Eastman and Jeffrey Clark are still defiant.
They've tried to destroy me, but I'm still standing and I'm going to keep fighting.
More than 3 years after they allegedly worked with then-President Trump to try to overturn the 2020 election.
Do you regret attaching your name to the former president?
None whatsoever.
John Eastman operated as the so-called architect behind the fake elector scheme.
It is a visualization designed to capture the essence of a truth that is too bureaucratic and too slow-moving to fit into a 60-second clip. But here's the reality. The underlying documented behavior of these lawyers in the real world is arguably more damning and more devastating than the dramatized version, because what has really happened is slower. It is more methodical. It is wrapped in the dry procedural language of plea allocutions and bar disciplinary hearings.
The request from federal prosecutors came as Trump's attacks against special counsel Jack Smith are now standard on the campaign trail.
He's a deranged human being. Those indictments aren't worth the paper they're written on.
And his social media outbursts, including writing, "If you go after me, I'm coming after you," prompted prosecutors to act, alarmed about the possibility that Trump could divulge sensitive information or even evidence in the case.
But it is also far more permanent. In real life, multiple Trump-aligned attorneys have pleaded guilty to actual crimes in sworn proceedings. Judges have slammed Trump's legal teams with brutal financial sanctions that climb into the hundreds of thousands, even millions of dollars.
And Jeffrey Clark instigated an intense pressure campaign inside the Justice Department to try to get DOJ officials to help overturn the election for Trump. Now, both men are facing professional reckonings. Eastman and Clark have been sitting through attorney disciplinary hearings in recent weeks and months that could ultimately result in them losing their law licenses.
A criminal conspiracy.
They are also both defendants charged in the Georgia election subversion case.
I'm here today to surrender to an indictment that should never have been brought. It targets attorneys for their zealous advocacy on behalf of their clients, something attorneys are ethically bound to provide, and which was attempted here by formally challenging the results of the election through lawful and appropriate means.
And yes, in real courtrooms with real consequences, judges have indeed ordered Trump-aligned lawyers to sit down, to be quiet, and in some cases to physically remove themselves from the well of the court. The dramatization you see in the thumbnails is just the movie trailer. The actual story is a multi-year, multi-jurisdictional implosion of a legal operation that thought it could treat the American judicial system like a public relations extension of a political campaign. Let me walk you through the roster of the fallen. This is the list that most people scrolling through the news cycle have never fully absorbed as a single cohesive narrative of collapse. She was the one standing next to Rudy Giuliani at the Four Seasons Total Landscaping press conference, spinning tales of Venezuelan dictators flipping votes and Dominion voting machines running on secret algorithms designed by long-dead foreign leaders. She was the architect of the Kraken lawsuits that promised to overturn the election, but instead just got laughed out of courtrooms from Pennsylvania to Michigan. Well, Sidney Powell pleaded guilty in the state of Georgia. She stood before a judge and admitted under oath to interfering with voting equipment in Coffee County. She admitted that the conspiracy theories she sold to the public were not just wrong.
His attorney disciplinary case has been unfolding in California. He's charged by the state bar with 11 counts related to his plot to obstruct the electoral counting process.
They're trying to take my bar license.
Jeffrey Clark's professional ethics trial started this week in Washington, D.C.
They were criminal. And because she took a plea deal, she did not just apologize. She agreed to cooperate. She agreed to testify truthfully against anyone else involved in that sprawling post-election operation. That means every meeting she sat in, every phone call she was on, every email chain she was copied on is now fair game for prosecutors. And then there is Kenneth Chesebro. This is the man who was not on television screaming about bamboo fibers in the paper. This was the quiet professorial back office lawyer who drafted the actual legal memos that provided the scaffolding for the fake electors scheme. Chesebro was the brains behind the idea of sending slates of alternate pro-Trump electors to Congress from states that Trump had actually lost, creating the procedural confusion necessary to pressure Mike Pence on January 6th. He pleaded guilty, too, in Georgia to conspiracy. He admitted in open court that the strategy he designed, the plan he sold to the Trump campaign as a legitimate constitutional option, crossed the line into criminality. He admitted that the scheme was illegal. And just like Powell, his plea came with strings attached. He has to cooperate. He has to turn over his files. He has to testify. The man who literally wrote the playbook for trying to steal the election has now admitted that the playbook was a crime. And then we have Jenna Ellis, the articulate defender of the effort, who went on every cable news channel that would have her to assure the base that the election was being stolen. In her plea hearing in Georgia, she broke down. She wept. She told the judge that she had failed in her duties as an officer of the court. She said she was deeply remorseful for failing to do the due diligence that her law license required of her. She apologized for pushing claims that she now formally and under oath admits were false. Think about the professional journey required to go from "the election was rigged" on primetime television to "I am sorry for pushing false claims" in a Fulton County courtroom. That journey ended in a guilty plea and a cooperation agreement. And this is just the Georgia cohort. The consequences extend far beyond the Peach State. In other jurisdictions, Trump-aligned lawyers have faced disbarment proceedings that have ended their careers. They have been hit with personal sanctions by federal judges who have grown tired of watching their courtrooms used as stages for political theater. They have been referred to state bar associations for professional discipline. The pattern stretches across the map. Arizona, Michigan, Wisconsin, New York, Florida, D.C. It is a national map of professional consequences. Let us slow down and really dissect what a guilty plea actually represents in the architecture of the law. People often confuse a plea deal with an apology or a settlement. It is neither. A guilty plea is a formal, irrevocable admission made under penalty of perjury. Before a judge accepts a guilty plea, they are required by law to engage in a colloquy with the defendant. The judge asks, "Are you pleading guilty because you are, in fact, guilty?" The judge asks, "Has anyone threatened you or promised you anything outside of the plea agreement to get you to say this?" The judge walks through each and every element of the crime and makes the defendant say out loud what they did to satisfy that element. It is a ritualized confession, and once that gavel falls and the plea is accepted, the factual basis for the crime is established as a matter of law. You cannot unring that bell. You cannot later go on a podcast and say, "Well, I did not really do it. I just took the deal to make it go away. The court record says you did it, period." Now, multiply that reality by 3. Powell, Chesebro, Ellis. That is 3 separate sworn admissions that crimes were committed during the execution of the post-election strategy to keep Donald Trump in power. Not alleged crimes, not politically motivated crimes, admitted crimes.
Shared a post on Truth Social calling for Democratic members of Congress to be hanged. He also posted a message that said, "Seditious behavior, punishable by death." Let's be crystal clear. The President of the United States is calling for the execution of elected officials.
And in the logic of criminal investigations, if crimes were committed, someone was at the top of the pyramid, someone gave the orders, someone coordinated the efforts, someone signed off on the strategy. The people who have pleaded guilty are, relatively speaking, the foot soldiers and the mid-level architects. But their guilty pleas create an evidentiary ladder. Prosecutors use the foot soldiers to climb up to the principals. The cooperation agreements that accompany these pleas are the key that unlocks the door to the inner sanctum. When Powell and Chesebro sit down with investigators, they are not just telling stories about what they did. They are providing context. They are explaining who told them to do it. They are authenticating documents. They are filling in the gaps of the timeline. They are, in essence, narrating the conspiracy from the inside out. For a prosecutor building a RICO case, and let us not forget the Georgia case was originally structured as a sprawling racketeer, influenced, and corrupt organizations case, insider witnesses are invaluable. They are the only way to prove the existence of the enterprise and the pattern of racketeering activity. These pleas gave the prosecution the keys to the kingdom, even if the driver of that particular car, Fani Willis, later faced her own procedural challenges. And beyond the criminal pleas, there is the slow, grinding machinery of civil sanctions. This is the part of the story that does not make for good viral clips because it involves spreadsheets and judicial opinions, but it is devastating nonetheless. A federal judge in Florida dealing with a frivolous RICO lawsuit filed by Trump allies against a host of political opponents did not just dismiss the case, he imposed nearly $1 million in sanctions against the lawyers who signed their names to the complaint. Let that number sink in for a moment. $1 million against lawyers personally. That is not a cost of doing business for a law firm. That is a career-altering, reputation-destroying event. Judges do not hand out $1 million sanctions for simple mistakes or aggressive lawyering. They reserve that kind of financial punishment for conduct that is deemed to be in bad faith, an abuse of the judicial process, and an attempt to use the courts as a weapon of political harassment. When a judge drops the hammer like that, it sends a shockwave through the entire legal community. It tells every lawyer in the country, if you sign your name to this kind of complaint, you are putting your personal assets on the line. You are gambling with your house, your children's college fund, and your future. The result is a chilling effect, not on legitimate legal advocacy, but on the specific brand of fact-free litigation that became the hallmark of the Trump legal strategy. The language that judges have been using in these cases is another signal that we are living through an abnormal period. Judges are trained from their first day in robes to be restrained. They are taught to use passive voice, to be clinical, to avoid anything that could be perceived as personal animus. Yet in case after case involving Trump's lawyers, the judicial vocabulary has cracked open to reveal genuine frustration, frivolous, profound abuse, revisionist myth, lawlessness. These are not neutral adjectives. These are judicial expressions of serious concern. When a federal judge in New Jersey looked at the situation unfolding in the U.S. Attorney's Office and demanded to know in open court who was actually running the office before ordering a Trump-era supervisor out of the room, that was not normal. That was a judge who had simply had enough of the games. And while the viral thumbnail of a judge screaming at a defense attorney is a dramatization, the real-life equivalent has happened. Judges have ended hearings abruptly. They have issued warnings from the bench that would make a first-year associate deeply uncomfortable. They have referred lawyers to disciplinary committees. The cumulative message from the bench to Trump's legal world is unmistakable. The grace period is over. The assumption of good faith is gone. You will be treated like any other litigant, and if you step out of line, you will pay the price. And then there is the professional afterlife, the bar associations. These are the gatekeepers of the legal profession. They move slowly, but when they finally reach their destination, they reshape the landscape permanently. Rudy Giuliani, the man once celebrated as America's mayor, is the ultimate cautionary tale. His law license has been suspended. He is facing disbarment proceedings. He has been buried under an avalanche of defamation judgments totaling hundreds of millions of dollars that he will never be able to pay. He has filed for bankruptcy. His legacy is not September 11th anymore. His legacy is the Four Seasons Total Landscaping press conference. He is a professional ruin, and he achieved that ruin by doing exactly what Donald Trump asked him to do. He made claims in court and in public that were demonstrably false, and the legal system processed him accordingly. John Eastman, the law professor who wrote the memos justifying the pressure campaign on Mike Pence, is facing disbarment in California and criminal charges in Georgia. His tenure as a respected constitutional scholar is over. His name is now synonymous with a failed effort to overturn a presidential election. For every lawyer watching from the sidelines, the lesson is brutal and clear. Proximity to Donald Trump is a significant professional risk. It might give you a temporary moment of media attention and fundraising activity, but the long-term exposure is almost always damaging to your career and your freedom. This is not just about a few lawyers having a bad day in court. This is about the systematic degradation of the legal shield that protects a political operation. When you cannot get top-tier lawyers to sign their names to your pleadings, you lose. It is that simple. The recruitment pool for Trump's most aggressive legal positions has narrowed. Serious lawyers at serious firms look at the sanctions, the disbarments, and the guilty pleas, and they do the math. The financial upside of representing Trump does not outweigh the existential risk to your professional license. So who is left to do the work? The true believers who are willing to risk their careers. The inexperienced lawyers who do not know better. The lawyers who have nothing left to lose. And when the quality of the legal work declines, the losses pile up faster. More losses lead to more sanctions. More sanctions discourage more qualified lawyers. It is a deteriorating cycle for the legal defense apparatus. And every time a Trump lawyer faces consequences, they take a piece of the operation's secrets with them into the prosecutor's office. So let us crystallize this into the 4 pillars of what this means and where this is going. The guilty pleas are the gold standard of criminal evidence. They are the cement foundation. Because Powell, Chesebro, and Ellis have pleaded guilty, there is no longer any credible debate about whether crimes were committed in the aftermath of the election. The debate is over. The only questions that remain are about scope and culpability. Who else was in the room? Who gave the approval? How high up the chain does this go? These pleas give prosecutors the factual predicate they need to keep digging, and they give them the witnesses to guide the investigation. Cooperation agreements are the gift that keeps on giving for law enforcement. These are not one-and-done interviews. These are ongoing obligations. Cooperators can be called before grand juries for years. They can be called as trial witnesses in multiple cases. Their phones, their emails, their calendars become part of the investigation. Every time a new piece of evidence surfaces, prosecutors can call the cooperator back and say, "Explain this email we just found." The evidence stream never stops flowing. It creates a permanent living archive of the conspiracy. Sanctions change the economic calculus of political lawyering. The $1 million sanction in Florida is a warning heard around every law firm in the country. It says that the days of filing lawsuits without a solid factual basis for political effect are over. If you want to file in court on behalf of Trump's causes, you better have a case that can survive Rule 11 of the Federal Rules of Civil Procedure. And if you do not, the court will hold you personally responsible. This is the system working as intended. It is the judiciary defending its own integrity against those who would treat it as a mere extension of the campaign trail. Who benefits from this mass of admissions? In the short term, prosecutors benefit. They have a stable of witnesses. In the long term, the rule of law itself benefits. When lawyers are held accountable for abusing the courts become stronger. The message goes out to the next generation of law students. You cannot sign your name to a false claim. You cannot file a frivolous lawsuit just because a wealthy client wants you to. The law is not a tool for political theater. And who loses? Donald Trump loses. Every single guilty plea is a former loyalist standing up in court and saying, "The operation I worked on was a crime." Every sanction is a judge saying, "The strategy you paid for is an abuse of the system." Every disbarment is the legal profession voting to expel one of its own for doing Trump's bidding. The accumulation of this evidence is significant. It paints a picture of a coordinated effort masquerading as a legal defense. And the people who lose the most, aside from Trump himself, are the lawyers. They have traded their reputations, their careers, and in some cases their freedom for the privilege of standing next to a man who would not return their phone call the moment they stopped being useful.